Hello, and welcome to the DC Insider Employer Update podcast. This podcast provides updates based on the expertise and insights from the attorneys at the Washington, D.C.-based law firm Fortney Scott and their guests. This podcast will provide an analysis of significant federal developments affecting the workplace that employers need to understand and is for informational purposes only and does not provide legal advice. Now let's turn it over to our host, David Fortney.
Hi, everyone, and welcome to another DC Insider Employer Update podcast. Got both Nita and Burt with me. Nita, how are you?
I'm great. Looking forward to the weekend.
Me too. Burt?
Glad to be here. This has been a busy few days.
Sure has. I mean, we all had to sort of interrupt getting the grill ready and getting our flags and bunting put up in order to plow through these Supreme Court decisions. I put air quotes around the best for last, but they certainly saved some of the most controversial decisions for last. And that's really what I think we need to spend a little time on, because although there's a lot of decisions that have affected and caught the public's eye and generally being discussed, we want to focus on the ones that really are going to impact the workplace and employers' interests most directly. And there, of course, were three significant decisions in the last couple days of the court's term this year that are mind-blowing. Honestly, just mind-blowing. This is the court's answer. We've been talking about the administrative state. Is the administrative state going to be rolled back, changed, altered? The answer is heck yes. And there are three decisions that we want to unpack a little bit and then talk in real terms about the impact on the regulations, which is quite significant, and what they are. So those three decisions, we have the SEC versus Jerkasy. Nita's going to talk about that a little bit. We have probably the big core decision that really drives so much of the changing rules of the road for the administrative state, called the Loper Bright Enterprise versus Raimondo, and the companion case, Relentless versus Department of Commerce. We'll just talk about that as the Loper Bright case. It was one single decision. And finally, a case that not a lot of people had paid attention to, but is a very significant case also to animate how these changes are going to occur, which is Corner Post versus Board of Governors of the Federal Reserve Board. Honestly, I think we have to go back to FDR and the creation of the New Deal and the establishment of what today, whether it's for pejorative reasons or otherwise, is often referred to as the administrative state, and that all of us have become so acclimated to, that governs every aspect of the workplace, all these federal agencies and the companion state agencies. What we are going to talk about in these Supreme Court decisions represent a complete reimagining as to how those agencies will operate, how their regulations will operate and be enforced by the courts, sub-regulatory guidance, and all aspects of agency enforcement of statutory obligations. And I don't think I'm overstating that. Do you, Burt?
Absolutely not. Absolutely not. I think this is a day to remember because it's changed the way the government will operate.
I think it's really important because it's going to make life for employers very difficult because they really are not going to know what the rules are until we get the tsunami of litigation that the dissent predicts as a part of Loper Bright.
All right. Well, let's get right to it and jump into those decisions. The first decision, which I view as kind of the cornerstone of this tsunami change, is the rollback of Chevron, and that's the Loper Bright decision. So, Burt, why don't you kick that off for us?
Well, I'll certainly try and create a synopsis. Loper Bright was a 6-3 decision authored by the Chief Justice, who took the leading role in writing two of these three decisions. This case overturned a 40-year-old precedent called Chevron versus Natural Resources Defense Council. Chevron asked judges to defer to the expertise of agency interpretations of difficult or ambiguous statutes. The new decision, Loper Bright, held that Chevron deference improperly transferred power to interpret laws from the judiciary to the federal agencies, and that is going to stop. As the Chief Justice wrote, courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority. The courts may not defer agency interpretations of the law simply because a statute is ambiguous. So this shifts the role from the agency's expertise in interpreting a statute to the courts deciding whether that agency has acted in concert with the statute. This is a sea change. This is a decision to remember. It's up there with Marbury versus Madison and others that you can conjure. But this is, as David said, an important linchpin in changing the way the government will operate.
I'll just add that the Supreme Court now has officially overruled Chevron. Many had viewed Chevron as having been sort of in practice overruled. At least the Supreme Court had the luxury of ignoring its own precedent, because for the last 8 years of Chevron's 40-plus year existence, since 2016, the Supreme Court hasn't cited Chevron one time. But of course, all the lower courts, they don't have the luxury of deciding whether to ignore or comply. And the Supreme Court went on at some length, kind of trying to detail all the struggles that the courts had had in some inconsistent applications of Chevron, because it had become fairly arcane in its application. But nonetheless, the core principle of deferring to agencies with expertise was firmly embedded in Chevron, and that is out the door. Well, Nita, what about the second decision, which is the SEC versus Jerkasy?
Well, this is a second decision, also a 6-3 decision, authored by the Chief Justice, in which the court held that when the SEC seeks civil penalties against a defendant for securities fraud, the defendant gets to go to federal court and have a jury, basically. The Seventh Amendment applies to any situation like this when it's fraud. And the court's decision was where you have common law types of allegations, those must be heard by an Article III judge, not by the SEC's in-house judges. While there is an exception for public rights, which are basically rights that are created by Congress, and we'll talk about what those are, anytime there is something that appears in common law, then you get a jury trial. And that raises many issues. So yes, we're talking about civil money penalties in the situation in Jerkasy, and we'll talk about other places. What are other types of common law actions that might be covered by Jerkasy?
One of the things that you'll notice immediately is this whole division between what is called law and equity. All financial penalties designed to be punitive or in some way not restorative are considered remedies at law, which means all of those administrative tribunals can no longer impose financial penalties of that kind. Every one of those has to be tried to an Article III judge. What do you think, David?
Well, certainly this breathes life into the concerns that many had stated that these agencies like the SEC, like the Labor Department, the EEOC in some cases, had the agency serving as judge, jury, and prosecutor. In certain cases now, that is clearly no longer the case, no longer permitted, because of the Seventh Amendment protections that attach for a jury trial. So I think, again, the line drawing is not clear. What the consequences of this are not clear, but it is significant. And it's broader than just which forum will be the place in which claims are adjudicated. Well, the third case, I'll just briefly talk about that. That's the Corner Post decision. I mean, gosh, Corner Post, they're just a little old truck stop up in North Dakota. So how do they end up in front of the Supreme Court? Well, they end up in front of the Supreme Court because they opened their business in 2018 and they're accepting credit cards. And of course, there is a regulation that the Federal Reserve promulgated dealing with the fees that merchants have to pay when they accept credit cards. And the truck stop, Corner Post, said, we don't like that. We don't think that regulation's fair, wasn't properly promulgated. We're going to challenge it. The problem is that they faced was, well, wait a minute, the regulation was promulgated in 2011. You have a general 6-year statute of limitations under the Administrative Procedure Act in which to file claims, and your statute of limitations would have run under that reading before the company even started business. So the court was torn with the question of, is it just when the regs were filed, the 6-year limitation, so that anyone that was out beyond that 6 year couldn't challenge the regs? or in this case, when a business was first exposed and had an opportunity to suffer the harm. The court went with the latter ruling. This is the 1-2 punch when you combine it with no deference to regulations that Burt talked about in Loper Bright, and now Corner Post, in which Justice Barrett, she authored this majority decision, again, another 6-3 decision, says, yes, we're going to allow these new claims to come forward, resulting, I should say, in Justice Jackson leading the dissent, warning, this is now going to create a tsunami of lawsuits. The settled expectations that a reg has been challenged, as this reg was, and found to be legitimate, now they get second bites, third bites, unlimited bites at the apple going forward. So this combined with Loper Bright, combined with Jerkasy, those are the big three.
You know, what's interesting about this Corner Post case is, David, and I know you're going to talk about this later, this really undercuts the Chief Justice's discussion in Chevron that cases prior to Loper Bright are still good law. I think that kind of blows a hole through that, in my opinion.
You know, one of the things that is most troubling about this case is that this very regulation was adjudicated back in 2011, all the way to the Supreme Court, cert denied. The one thing that most businesses need to function is some stability, some certainty. Yes, you could always challenge a regulation, and many people did, but once it had been adjudicated, everybody thought it was over. Now, there's an opportunity. In fact, what's troubling about the court's decision, it seems almost to invite challenges to old regulations that everybody has depended on, that have built and structured their business operations on, are now in play. And we no longer have the kind of finality that a court, especially the Supreme Court, is supposed to bring to an issue. They're the ones that are stirring the pot.
One last thought before we talk about the impact on employers. The agencies, I think, that are going to be most impacted by this are not really the agencies we live with, the workplace agencies that do enforcement. I think it's going to be EPA and some of these agencies where there's a lot of objection to the type of work they've been doing. And I think that's where you're going to see the court stepping in, and will they have the expertise to decide whether or not a particular regulation is something that's needed?
Well, certainly with the seismic change in the rules governing challenges to the so-called administrative state, I think all stakeholders, let's start with employers. Burt, your point on stability, predictability, consistency, it's kind of out the door. You know, we were chatting in advance of this, and Nita, you pointed out the impact of the abortion ruling and how that's digressed to the 50 states. Well, now we can think about administrative challenges to administrative regulations, guidance, a whole host of actions, digressing to 94 district courts, I believe, all the courts of appeals. And what does that mean for employers, multi-state employers, multi-district employers? You may have a variety of different rules governing you. And the same for the agencies. What standards are they enforcing? Traditionally, the agency will follow the law of the Supreme Court, of course, but then the law of the circuit. So the agencies themselves may be going multiple directions, not to mention in developing or amending new regulations. And so I think it's going to be quite chaotic. I don't know if it's going to be tsunami, but it's not baffling to me, as the justice said. I don't think it's baffling at all. There's going to be widespread challenges. Let's kind of pivot. That's sort of the backdrop. And then what I want to do, because I think most people are like, okay, conceptually, we get it, we hear you, but how does that apply day to day in terms of the actual regulations that are on the books, what employers are currently doing? And I think that there are a number of regulations that are worth noting that just, I mean, without the benefit yet of even litigation that we anticipate coming, we can predict with a high level of certainty are directly impacted by these Supreme Court decisions. I'm going to start with the Labor Department. They're one of the biggest regulators affecting the workplace. So let's start there and let's talk about the wage and hour regulations. There have been some very high profile regulations. Start with the white collar exemption regulation. They're very controversial that they have elevated the salary test. They put in a two-step elevation in the regulation. There's already litigation pending. But now certainly the question is, I mean, we haven't referenced this yet, but what the court has already given us the major question doctrine. That's how you first start. Does the Fair Labor Standards Act authorize a salary test as part of the white collar exemption requirements? That's an open question. The potential answer is no. Then second, in terms of the agency's decision, whether it can sustain the decisions or whether they'll be challenged as being not authorized by the statute in terms of what the duties are, how the duties tests are to be applied. And under the new Loper Bright decision, I think that the agency no longer gets the benefit of the doubt. And final point, I'll just say, having been a regulator once, I mean, I guess it's good we all confess what we've done in the past. I was a regulator. Burt, you've been a regulator. And there were times where it was a close call. And I knew as a regulator, because I had Chevron on my side at that time, if I made a call, even if the court didn't like it, more likely than not, the court would defer. That's gone. Now it's up to the court to decide what the statute authorizes.
You know, David, already the Fifth Circuit has got a challenge to the Trump overtime rule from 2019, and they have asked for briefing on that. And I think you will see the salary basis test go back to the Supreme Court, where Justice Kavanaugh a couple of years ago begged for someone to bring that up to the court.
Agreed. Two other wage hour regulations real quickly to put on the list. One includes the independent contractor rule. Same arguments. We've just gone through to challenge the white collar exemption regulations. High likelihood of success. And finally, the child labor regulations that have been very active recently, and the Labor Department almost weekly announces resolutions that include civil money penalties. If you look at those regulations for CMPs, as they're called, they are dependent on an adjudication before a Labor Department administrative law judge, quite similar to the claims that Nita described were taken down in Jerkasy, and likely those regulations also are on thin ice. So those are at least three wage hour regulations, I think, on the short list that we can feel confident will be directly impacted by these decisions. Nita, what about OFCCP? They are also pretty significant, both regulations and guidance.
Well, what's interesting about OFCCP is generally all they're seeking are either back pay, front pay, and possibly they also have reinstatement. None of those fall under the requirement to have a jury trial. However, I think, David, when we talked before, when 11246 was initially passed, these were considered breach of contract claims. So the underlying claim may be a legal remedy, and that was actually taken into court by the Department of Justice back in the day. We also know that in addition to everything else, there are a number of cases moving through the system. The one most likely to get to the Supreme Court is one out of the 10th Circuit that has to do with the Procurement Act and whether the president has the authority under the Procurement Act to issue these executive orders like 11246 and require federal contractors to be in compliance. And if President Trump gets reelection, then in that situation, he's already pretty much said he's going to eliminate 11246, which he can do once he becomes president again.
So, Burt, let's pivot. We could spend all day on the Labor Department, but I don't want to ignore OSHA. They are probably the biggest regulator over at the Labor Department. What are the high points on OSHA that you see in light of these new decisions?
Yeah, well, frankly, OSHA is probably the poster child and was the chief focus of the target, really, of many of the challenges to the so-called administrative state, largely from the fossil fuel industry, somewhat from automakers. For OSHA in the short term, there are two standards that are probably going to be challenged immediately. One is the so-called walk-around standard, which permitted businesses to introduce third parties, including plaintiffs' lawyers, union reps, on a OSHA walk-around, that is to say, to see if there are violations. And just today, a new heat standard has been issued, again, likely to be challenged on the grounds that the temperature cutoff is arbitrary and capricious. This is similar to the vaccine mandate, which started this whole epic, as well as being a challenge to the agency's statutory authority. And I think we're going to see a lot of action here. The unanswered question in light of The ambiguity that these cases create is whether and to what degree OSHA can issue regulations under what is called the General Duty Clause. The statute gives OSHA the authority to protect workers as a general principle. The question is, can general delegations of regulatory authority survive? And that's a crucial question because many of the New Deal statutes, many of the statutes that are now like 90 years old, have very broad delegations of authority. The secretary shall, but they are so broad as to perhaps be ineffective. And I think that's where the real Supreme Court decisions of the future are going to focus.
And OSHA, of course, the OSH Act is only 50 years old, but as you point out, it already has been criticized by the Supreme Court when OSHA tried to impose the requirement for the COVID vaccine under the major question. So I think OSHA regulations, I agree with you, are going to get very close scrutiny, and this provides a very strong tool to roll back a number of OSHA regulations, which, again, to the chaos point we talked about before, there's a lot of what happens then, what happens in the context of state plans that are supposed to follow OSHA regulations. I mean, there's a lot of ramifications if an OSHA regulation gets pushed back, particularly one that's been on the books for quite a while. Well, let's jump from the Labor Department to one of the other primary federal agencies governing the workplace, which is the EEOC. Not necessarily a big regulator, but Nita, what do you see going on there?
Well, generally, you've got with Title VII, ADEA, ADA, and the Pregnant Worker Fairness Act, you basically don't have remedies that are going to violate, that Jerkasy is going to implicate, because the EEOC files in Article 3 federal court. So from that perspective, that is okay. Generally, I think what they do meets the major question test under Loper Bright. However, we are seeing right now, the EEOC generally does not have authority to issue regulations. However, they did get directed by the Congress when they passed the Pregnant Worker Fairness Act to issue regulations, and those regulations have been the subject of litigation, and some litigation which in fact cited Chevron and deferred, although there were also standing questions. So I think the new PWFA regulations as to the abortion accommodation, as to the breadth of the things that are covered as related medical conditions, and also as to the 40 weeks that they can go without doing the essential functions. All of those things, I think, pose opportunities for plaintiffs under the regulations after Chevron.
You know, Nita, I think the pregnancy regulations are a locus classicus here, where you have an agency with expertise in precisely this area, calling upon clinicians, calling upon therapeutic doctors, and then deciding that abortion-related medical conditions are related, obviously, to pregnancy. One does not have an abortion unless one is pregnant. That is the kind of thing that we used to regard as normal for an agency to do, to interpret a regulation in light of what the underlying statute is intended to cover. And it's now an issue in controversy. And because of Loper Bright, the expertise of the agency will no longer receive deference, and we'll have judges who, last time I looked, have many degrees, none of them have MDs, making decisions on this rule.
Well, indeed, picking up on that, Senator Cassidy, the ranking member on the Senate Help Committee, has already launched. So it's not only judicial challenges, now we have congressional oversight being launched directed at the EEOC, basically saying, wait a minute, where did you come up with abortion, including it? My copy of the PWFA statute doesn't include abortion. It includes pregnancy. Pregnancy is not abortion. It's a separate procedure. If we, Congress, wanted that in, we would have said so. And you can hear the Supreme Court in a fairly mechanical way. Major question, was it in the statute? No, it wasn't. Did the agency run rogue and put their own interpretation, usurping legislative function by including this? Yes, they did. And we don't need to defer because we don't have Chevron anymore. That simplistic analysis is more likely than not, in my view, to impact certainly that component of the PWFA regulation. And I just want to build on, if that occurs, does the rest of the regulation stand? Do we follow what's called blue penciling, as we do sometimes with employment agreements? Or does the entire regulation get knocked down? I don't know the answer to that.
If passed as prologue, the whole regulation goes. The court usually does not ask an agency to enforce a regulation it has not proposed. So it remains to be seen, but if precedent still exists, that's the precedent.
Right.
One thing that's been talked about is whether the agencies can now issue sub-regulatory guidance rather than regulations, but EEOC is getting lawsuits over their harassment guidance. And in fact, they had issued guidance after Bostock, and that guidance was blocked by several federal courts as being beyond what Bostock allowed.
And I might add to that point, Senator Cassidy's also picked up on that point for purposes of congressional oversight. So a lot of developments. So even though Loper Bright was really focused on regulation, this illustrates the breadth of it. It goes to sub-regulatory guidance, which agencies might otherwise be inclined to try to pursue, since regulations may be tough sledding. But even that won't be immune or outside of scope of being potentially reviewed and or challenged. Well, Burt, let's go to the third and other major labor regulator. That's the NLRB, which has probably been the biggest regulator for all employers, union or non-union.
Certainly the most controversial and perhaps the most active. But the NLRB issues few regulations, so Loper Bright is only tangentially affecting them, although it doesn't escape, and I'll try to show why. One, in a break with the past, the NLRB has issued a very significant regulation on the joint employer issue. It is now pending before the courts, and all of the reasons that we've been articulated that I won't repeat, even though the regulation would fundamentally change the law, it will receive no deference from the courts. The courts have been skeptical to start with the board's expansive redefinition of its own authorities. Now, as to how other NLRB actions will be assessed, for the most part, NLRB's remedies are what they call equitable. They are back pay, make-whole remedies. They are not intended to punish. They're not intended to fine. They're intended to return things to the status quo ante. But recent efforts by the board to redefine the breadth of make-whole remedies to include consequential losses like rent, like medical expenses, car payments, I think will find a very critical reception in most courts. And then there is the suggestion by the General Counsel to impose civil money penalties, which are fines. And frankly, they're gone. Forget it. The NLRB has no way to impose legal remedies, never goes to court to do so. And I think the case that's in the works that seeks to impose civil money penalties is a dead letter. And that's how I think, because they're mainly equitable, many of their remedies will not be touched, but they will have tough going for joint employer and for expanded civil money penalty remedies.
I think that's right. And I just want to round off this discussion of the agencies quickly on one non-traditional agency that has put its nose under the tent of the workplace regulatory environs, and that is the FTC, which of course promulgated this spring a highly controversial regulation effectively banning non-compete agreements across the country. Many people were sort of taken aback the breadth of that regulation. I think, well, lest there be any doubt before as to whether they had authority to do that, I think that in light of the precedents we've just covered, the non-compete regulation is effectively DOA. And I'll say that without qualification. It is gone after these rulings. Well, so those are some examples of regulations on the books, but from the business interest, it isn't just regulations on the book. We also are concerned about future regulations. And I want to pull down one topic that has been the source of repeated requests by the business community and many other stakeholders to actually impose regulations. And that's in the field of artificial intelligence, AI. Up to this point, I think it's fair to say most entities have been working very hard to reimagine current statutes and try to impose new regulatory relief and requirements to govern AI. Where are we going with that now?
Well, from my point of view, that's the problem. That's really the major question. We don't know, and frankly, neither do the justices. How will the government be able to respond to future needs, some of which aren't even identified? Judges are reactive, they're not creative, and yet they put themselves in the center of the government. You know, it could be AI, which is not mentioned in any statute. We just don't know. The combined impact of the three decisions that we've been talking about pretty much deprives the executive branch of its ability to articulate its vision, which is a problem for me in a democracy. After all, presidents are elected to execute their vision through legislation, through regulation, and they are answerable to the electorate. No one ever elected a federal judge. And the real question is, are we content with this situation? Is this how we want to have our government run?
I think really, the other question, going back to the Fifth Circuit, is there is going to be another run at the administrative state. We are not done yet. I think we can expect, especially in the Fifth Circuit, there continues their prior ruling in Jerkasy stands, and they found that the administrative law judges under the SEC are unconstitutional. That stands for the Fifth Circuit, at least for now. And I think, we have to see where else the other circuits go around what's going to be left of the regulatory areas that we're used to.
The question raised in the Fifth Circuit's decision in Jerkasy wasn't really answered in the court's ruling, and that's whether the structure of the SEC is constitutional. There are a number of cases challenging the NLRB's structure as unconstitutional by some very well-heeled clients, SpaceX and Starbucks. The entire system of administrative law is now under unprecedented pressure. And David, you mentioned this earlier, the lack of practicality. These decisions don't seem to care about the practical impact of the ruling. It's almost like law review articles, and yet they're affecting the livelihood of the economy and the lives of millions of citizens. And we just don't know how this is going to play out.
Well, I think that's right. And what we can say with certainty is a new day has dawned. The future is quite mixed. But I will say, employers out there, if you do face an agency enforcement challenge, whatever you may think of this, you need to be well aware of this and determine whether there are now additional defenses that you might be able to raise. Is the regulation or the interpretation that the agency is using to allege a violation, is it bona fide under these new standards? And as defense counsel, there's at least an obligation to make sure you go through those arguments. They're new arguments, and you would be remiss not to look at those also. Whether it's a good thing or not in the long run, there's a lot of concerns, and those have been highlighted.
No deference, no statute of limitations, no business can plan for tomorrow. The justices never met a payroll. The justices never dealt with a lost job or a debt due. And there are many uncertainties resulting from these three decisions, but there is one thing that is certain. And to rely on Justice Jackson's dissent in Corner Post, there is a lack of certainty for employers and employees.
And looking at what we've talked about, I think the majority said, well, if you don't like it, Congress can change it. But we haven't seen Congress be able to do much of anything in the last few years because there's no willingness to compromise. So I think at least for the foreseeable future, chaos is going to reign.
I'm kind of of the same view. I do note that, Burt, you mentioned Justice Jackson's dissent, which talks about the tsunami of lawsuits that will be brought against agencies, the potential to devastate the functioning of the federal government. Even though Justice Barrett found that to be baffling and bizarre, her words, quite bizarre, it's not. It's reality, but it is our new reality. We're going to come to grips with it and deal with it. And I just want to thank you both. This is a really both scary but intellectually exciting time. But for employers that have the practicalities of running a business, it's going to be very challenging. That we can remain confident of. So let's leave it there. We've been a little longer than usual. Burt, Nita, thank you both so much for today.
Pleasure.
Thank you.
And for everyone out there, if you haven't already subscribed, please do. We really appreciate it. Got a lot of people listening, and we're going to keep coming at you with these topics. And we're going to unpack the themes that we've laid out here a little bit as the decisions keep coming, because now the lower courts have the action, and we're going to see a lot more from what we've laid out today. Thank you.
Thank you for listening to the DC Insider Employer Update, the podcast that provides analysis of significant federal developments affecting the workplace that employers need to understand. You can subscribe to the DC Insider Employer Update podcast wherever you get your podcasts, which includes Apple, Spotify, and Google. Additional information about our podcast is located on the Fortney Scott website at fortneyscott.com. Thanks again for listening to the DC Insider Employer Update.